welcome to another episode of the DMH Stallard Private Wealth Podcast. I'm Emma Weir, a partner and group head of our private client team in the Hassocks office, and I'm delighted to be joined today by Rachel Osgood, a partner in our family team in the Guildford office, specialising in advising clients on the protection of assets in relationships and on divorce. And I'm also delighted to be joined by Jade Payne, a senior associate in our private client team in the Hassocks office, offering specialist advice on farming estates. Today, we will be discussing the incredibly important and topical subject of farms and agriculture in light of the significant changes announced in the budget in October last year. There are approximately 209,000 farm holdings in the UK, and farm and agricultural land accounts for approximately 70% of all UK land. There are also around 462,000 people employed in the farming and agricultural sector. And so any changes to reliefs and planning could have significant consequences for a large number of people. And we shall be discussing this incredibly important topic today. Jade, I wanted to start with you and ask you, what actually is agricultural property relief, and what do we mean by agriculture in the context of this relief?
Thanks, Emma. So, agricultural property relief is a form of inheritance tax relief. It has the effect of reducing the value of someone's estate for inheritance tax purposes. It applies on both gifts left in wills as well as for lifetime gifts. So, agriculture itself isn't defined anywhere. Agricultural property is, and it is stated to be agricultural land or pasture and includes aspects such as woodland and buildings, provided that they are ancillary to the agricultural land. Now, agricultural land means the land must be given over to agriculture. HMRC recognise aspects such as cultivation of produce food for animal or human consumption, land set aside for rotational flow, use of livestock for human consumption, including wool, eggs, meat, etc., and keeping of animals ordinarily found on a farm, such as working horses.
So, what does not qualify as agriculture for the purposes of the relief?
Absolutely. So this is assessed on a case by case basis. So the likes of machinery and stock are actually not covered by agricultural property relief, but may be covered by another form of inheritance tax relief known as business property relief. The matter of horses is quite interesting in the context of agriculture because the legislation provides that stud horses and the rearing of horses on a stud farm and the grazing of horses and buildings associated with that would be covered for agricultural property relief, whereas paddocks used for horse riding or DIY livery services do not qualify for the relief. So other aspects which won't qualify are woodland, which is not ancillary to the agricultural pasture or land, the likes of oyster beds, any buildings used to raise animals that's then used for sport, and fundamentally, if the land is not used for agricultural purposes. With the recent changes to various agricultural grants, there has been a greater need for farmers to diversify in their practices, and a lot of the diversification, such as car boot sales or quad bike racing, wouldn't necessarily qualify for agricultural property relief, but some may qualify for business property relief. It's really a question of fact and degree as to whether or not agricultural property relief will apply to someone's estate. And for example, it may not qualify for a cottage, but if that cottage has an orchard and the apples are harvested and then sold and the land is used for grazing of animals, for example, that part of the land might qualify for agricultural property relief, whereas the cottage itself wouldn't. What I should bring to everyone's attention is if there's any binding contract for sale over the land or asset when it's either given away or left in someone's estate, then agriculture property relief simply does not apply.
And you mentioned, there a little bit about cottages, etc. So, what about farm buildings, farmhouses? Are they covered by the relief?
So it really depends on the type of building in question. So farmhouses can be covered by agricultural property relief, but they need to be occupied by the farmer, and it needs to be a place from where the farm business is managed. For farm cottages to be included under agricultural property relief, the requirement is that they have to be occupied by a farm worker. Any building on a farm needs to be used for agricultural purposes. So if it is not ancillary to farming, it is not going to qualify for agricultural property relief. The likes of farm cottages and farmhouses need to be character appropriate. So, for example, a modern house on a piece of land is not likely to qualify for agricultural property relief as it's not in keeping with the farmland. And there is a very peculiar distinction in the law between the difference between land with a house and house with land. You are more likely to qualify if the asset in question is a large portion of land with a smaller property, whereas you're less likely to get the relief if there's a larger house but with a smaller acreage. So if you've got a farm where the buildings dominate the land rather than being ancillary to it, you're less likely to qualify for the relief.
And so, how are those agricultural assets actually valued?
It's a really good question, Emma. I mean, fundamentally, it is for a specialist valuer to come in and let us know what the value of the particular assets are. It'll be up to HMRC at the end of the day as to whether or not they accept the values. But one thing that should be noted is that even if an asset qualifies for agricultural or indeed business property relief, it doesn't mean that the whole of the asset will qualify for the relief. So, what we commonly see with farmhouses is about 70% of the value of the farmhouse would be deemed to be agricultural value, whereas the remaining 30% would be deemed to be someone's home and therefore wouldn't be subject to any agricultural property relief. It's not at all uncommon for farms to have various assets, some which do not qualify for the relief at all, some which qualify for some relief but not all, and whereas certain aspects to have applied all of the relief. So factors taken into consideration is the difference between market value and the agricultural value. And they look at things such as how close a farmhouse is to a capital in the UK, how much work is needed to be undertaken to the farmhouse, such as its state of repair. So it's not as straightforward as say, oh, I have a farmhouse, therefore it's going to receive 100% APR. Unfortunately, it's a little bit more complicated than that.
So, what are the current provisions that actually relate to agricultural property relief?
So currently, provided the asset qualifies for the relief, then the amount of agricultural property relief, as well as business property relief, which I have briefly touched on earlier on, it's unlimited. So that means whether you've got £500 worth of assets or £500 million worth of assets, currently that relief is unlimited. There is a distinction in the legislation as to whether you are a farmer farming the land yourself or whether you are somebody who owns the land which is then being farmed. So if you are a farmer and you're farming the land yourself, you have to own the land for a minimum of 2 years in order for the relief to apply to your estate. If you own the land and it is being farmed on, then you have to own it for at least 7 years in order for the relief to qualify. So that's the likes of your investors who are purchasing agricultural land and then renting it to farmers to be farmed on. Currently, there are two rates of agricultural property relief. The first is 100%. This is the most common agricultural property relief available. The 50% agricultural property relief is available when there are certain tenancies that were created prior to 1995. When we talk about rates of relief, what it basically means is that it reduces the value of the asset by that percentage. So if you have an asset which qualifies for agricultural property relief, or indeed business property relief, which I touched on earlier, if you are eligible for 100% relief over that asset, then in effect, it is treated as if the value of that asset for tax purposes is zero. So in effect, you do not pay inheritance tax over that particular asset. Whereas if there is an asset which qualifies for 50% of the relief, it is treated as if the value is halved and then you're only paying inheritance tax over half of the asset.
And of course, we know that some significant changes were made to agricultural property relief and indeed business property relief in the budget last year. Can you talk me through those changes and what the government are proposing, and what the possible consequences of those changes might be?
Absolutely. So fundamentally, they're not changing the requirements to be eligible for agricultural business property relief. So the amount of years the land is owned and the types of asset which will qualify for the relief fundamentally haven't changed at all. However, rather than the relief being unlimited, it's due to be capped at £1 million, and everything else thereafter is taxed at the rate of 20% as opposed to 40% of inheritance tax. So to give you an example, so if there were £1.5 million of eligible agricultural and business property relief, and there are other assets in the estate which have utilised an individual's personal inheritance tax allowances, that first £1 million would be free of inheritance tax. The following £500,000 would be valued as if it was £250,000, and so inheritance tax of £100,000 would be payable. Now, it should be noted that these changes are proposed to come in as of the 6th of April 2026. They have not yet been made into legislation. However, it seems incredibly unlikely the government are going to backtrack on this. Some inheritance tax allowances are transferable between spouses, but the information that we're getting from HMRC is that this isn't going to be the case. Therefore, for people who have both agricultural and business assets, it may be advisable to start considering lifetime planning. Currently, under the inheritance tax provisions, if you make a lifetime gift and you survive 7 years from the date of that gift, it no longer forms part of your estate for inheritance tax purposes. So if you give away £1 million of agricultural or business property relief qualifying assets and then live 7 years, in effect, you've given away £1 million worth of assets. Your £1 million allowance in effect resets. So you could make further gifts or leave further business and agricultural assets in your will to the value of £1 million before paying any inheritance tax on that. So there is quite a significant scope for lifetime planning, especially between spouses, to make sure that farming couples are utilising their own £1 million allowances. As I said earlier, it's not likely it's going to be transferred between them. There is no inheritance tax or capital gains tax which will be paid in regards to gifts between spouses or civil partners. So in effect, by gifting assets to a spouse, it's going to increase a married couple's allowance from 1 million to 2 million. Whilst there being no immediate charge to inheritance tax or capital gains tax on the gift between the spouses or civil partners, for the recipient of the agricultural land to qualify for the relief, they would have to own the land either for 2 years if they're actively farming it, or else 7 years if they are not, before being able to pass it on and for it to qualify for the relevant agricultural property relief, either by their will or by lifetime gift. It's not clear exactly how this is going to react with other inheritance tax reliefs, such as the residence nil rate band yet, but we are awaiting further guidance from HMRC. There is also a greater scope to potentially look at creating some lifetime trusts over agricultural and business property if individuals are minded to make gifts to children or those who they want to be taking over the business but still want to retain an element of control, then a trust may be a useful structure in which to do so. There are some rather complicated and convoluted transitional parts of the legislation which are being proposed in regards to trusts, so I'd really strongly recommend that an individual seeks their own independent legal advice before considering settling assets into trusts.
Thank you, Jade. Yeah, that was really useful. And you're exactly right that it is such a complicated area that it certainly is. There's a lot of scope for planning, but equally, there's a lot of scope for getting things wrong. So the advice is absolutely to take legal advice. And as a fellow private client solicitor, our role, of course, is about helping farming clients to plan ahead to minimize any tax that they may pay and maximize the assets which are passing down to the next generation, which of course is important when it comes to farms who, the intention generally is to pass them down through the generations. But now, Rachel, of course, that could potentially cause some conflict with your role, um, and advice that you would give. And could you just talk to us about that and about your role as family advisor in these types of estates?
Yes, thanks, Emma. Yeah, there's a potential here for some real conflict and tension between the advice given from your perspectives as private client lawyers and my perspective as a divorce lawyer. We're all in the business of protecting assets for our clients, you particularly on death, and me particularly on relationship breakdown. But your means of protecting assets for your clients could well provide scope for significant problems in the context of what I'm dealing with, breakdown of relationships. So, Jade, you talked about the scope for lifetime planning and making gifts during your clients' lifetimes so that hopefully you can garner as much relief as possible from inheritance tax. But if, for example, we're talking about farmers here in particular today, your clients were to gift farming agricultural assets to their children, then and if the children were then to enter into relationships or are already married, then those assets become relevant if those children were to subsequently divorce or separate from their partners and potentially could become part of the matrimonial pot, which would then be shared between the separating or divorcing couple. So, meanwhile, your clients who gifted the farming and agricultural assets could face the prospect, worst case scenario, of their farm, which might have been handed down through the generations, being broken up as a result of the divorce of one of their children.
No, absolutely. And what I advise all clients is tax is only ever one consideration. The individual needs of each client need to be addressed, and situations such as that are obviously wanting to be avoided. So we look at the context as well as to what the client's business needs are as well, and fully appreciate that taxes is only ever one consideration.
Absolutely. Thank you. And when I'm seeing clients in this context, and often, I'll be saying to people, if you're acting for the older generation and they're talking to you about lifetime planning, then have that conversation with them about measures they can take, steps they can take with their children to further protect the assets if they are going to gift them down the generations. So often we'll be talking about prenuptial or postnuptial agreements in this context. And so I referred earlier to the matrimonial pot. When people get divorced, the assets that are available, if they're matrimonial in nature, are subject to a presumption that they'll be shared equally between the divorcing couple. So, of course, if those matrimonial assets include the farming assets, which one of the parties inherited or were gifted from the parents, then that leads to the potential for the farm being broken up if the spouse is entitled to a share of those assets on divorce. So what a nuptial agreement can do, either pre-marriage or post-marriage if necessary, is to try to ring fence those farming and agricultural assets so that they don't form part of the matrimonial assets should that couple then later get divorced. So there is a difference when you're dealing with a divorce between matrimonial assets and non-matrimonial assets. Matrimonial assets are those assets which the parties have accrued during the marriage as a result of their joint endeavours, their partnership, if you like, their marriage partnership. So typically it would involve, the matrimonial home. It would involve accumulated savings and investments and money and property accumulated as a result of their working, bringing up the children together and all the rest of it. So those assets, as I say, subject to the presumption that they'll be equally shared on divorce. But non-matrimonial assets, a different class of assets, are not subject to that presumption. So non-matrimonial assets are those assets which have come in from outside the marriage, that haven't been brought in as a result of the couple's joint endeavours. So they might include if, for example, one of the parties was in business prior to the marriage and brings that business to the marriage, then the business itself would be non-matrimonial. One or both of them may have owned property before the marriage. That might start off as non-matrimonial. If the parties receive gifts or inheritances during the marriage, and that's what we're talking about today, so
parents of one of them are gifting farming and agricultural assets to one of them, that would also be non-matrimonial to begin with. And at the end of the marriage, if the couple separates, those assets are not subject to that presumption that they'll be shared equally. Will they be shared at all? Possibly. That will be dictated by need. If we need to get access to those non-matrimonial assets to meet the needs of both parties, then they will be shared to the extent only necessary to meet the other party's needs. So the purpose of a nuptial agreement made either pre or post marriage would be to specify which assets are matrimonial and which assets are non-matrimonial. So you're looking at assets handed down from parents to do with the farm. They would be explicitly classified as non-matrimonial assets and ring-fenced so that they wouldn't be subject to this presumption of equal sharing. Now, nuptial agreements in English law are generally said nowadays to be enforceable, subject to adhering to some fairly strict criteria. In true English legal style, the criteria are flexible, they're bespoke, and they're sometimes difficult to pin down. So clients would always need some quite specialist advice about the agreement before it's finalised and signed up. It needs to be fair. Well, what on earth's fair? What's fair to one couple might be outrageously unfair to another. It's a question of context, and it's at the very least a question of meeting the weaker party's needs. And again, needs is a flexible concept that is case and fact specific. So if you're talking to clients who are considering lifetime gifting, then I would, really strongly suggest that you have this conversation. Sometimes it can be awkward, but actually sometimes it can be a really healthy conversation to have between the generations and between couples about the need to protect these assets and how best to do it so that everybody gets, what they need at the end of the relationship, but without having to break up the farm.
So, I mean, the key thing from a family perspective then is that families should take advice sort of prior to marriage in respect of farms that they may own, but also, on divorce as well. And of course, any time that they're considering making those gifts, they should, as well as taking estate planning advice, take some family advice.
Yeah, no, absolutely. Because Jade referred to the fact that, once the children of the farmers have received assets, they themselves might gift them or gift some of them to their spouses. So advice at all stages is absolutely essential, I would suggest, just to make sure that the intentions of the older generation are taken into account, as well as the needs of the younger generation, as well as the tax consequences for everybody.
That's great. Thank you, both of you, for providing incredibly useful insight into this highly important, I'd say highly emotive subject as well. Generally farms are generational businesses and have perhaps been in families for many, sometimes hundreds of years, I think. So it's really important from all sides to gain that perspective. And the one thing that's obviously crucially clear is from our discussion is that farmers and farming families, indeed, they need to receive advice at various stages, both in terms of asset protection, of course, during lifetime and also after they've passed away and the farm then passes to the next generation. If anybody that's listening would like further legal advice, please do get in touch with us at dmhstallard.com. Thank you for joining us today for this episode, and we will be back soon with another episode of our Private Wealth podcast, and do hope that you will join us again.